countries. These drafts were developed by the working group of experts. First of all, these were the experts from the Center for Political and Legal Reforms, and it was part of the implementation of the project of the Strategic Advisory Group with the financial support of International Renaissance Foundation. Why today we have started working on these drafts, and what is the main innovation in those drafts? First of all, after the beginning of the work of the Verkhovna Rada of Ukraine, the new cabinet of ministers is being formed. And it is important for newly appointed ministers to start their work immediately in new legal framework. We all understand, we all remember how people were talking, starting from the times of Maidan, that we need to change the system of organizing the authorities. And when we start looking at that, we see that in organization of the Cabinet of Ministers, of the ministries, and other executive bodies, there are many problems which make impossible to efficiently implement the functions of conducting reforms in different spheres of the life. And all these drafts are directed, maybe not to remove, but to minimize the institutional barriers which make impossible for ministers to efficiently work and implement reforms. Before we talk about the content of these drafts, I would like to touch upon some other important things. Very often the journalists ask questions about that. First, how to form the cabinet of ministers. The discussion is now whether the cabinet of ministers could be formed, could be approved as in a package, the whole list, or every minister should be approved separately. And we believe that this should be reflected in the new law on the cabinet of ministers, and according to the experience of other countries, the government should be approved as a list, as a package. The discussion of every candidate to the position of a minister, vice prime minister, should take place individually. Every one of the candidates should present their competencies, but the government should be approved in a package. This should be the agreement between the prime minister with the parliamentary majority. It's not normal if the Verkhovna Rada starts selectively approve some of the candidates suggested by the prime minister, and they would approve some of them and not approve others. In this case, the prime minister has the situation that it is difficult for him to become responsible for the activities of the government, because this way the prime minister cannot form the government out of those people who he trusts. Also, there is a proposal which also is worth discussing, and that is that together with approving the Cabinet of Ministers, it's worth approving the program of activities for the Cabinet of Ministers. Today, the government, after being appointed, has to prepare and submit for the approval the program of activities of the Cabinet of Ministers. And because of such process, we saw how the government would be formed. It would start working, but would never submit for approval the program of activities of the Cabinet of Ministers. At least that was the case with Azarov's government. To avoid that, we believe that the law on the Cabinet of Ministers should state that the program of activities, or at least the draft program, is to be submitted together with the list of the members of the Cabinet of Ministers. The next problem, which is very topical, is the status of so-called regulatory bodies. These are the bodies like the national commissions in the sphere of energy, communication, National Commission on the securities market, and we believe that from the point of view of theory, it was a mistake when these commissions were classified as the central executive authorities, and that is what the present law on Cabinet of Ministers has. And because they are central executive bodies, their members are to be appointed by the Cabinet of Ministers or the Verkhovna Rada after the Cabinet of Ministers submits them. But the nature of these bodies is that they are to be independent from the Cabinet of Ministers. If they are subordinate to the Cabinet of Ministers, then they are not needed. The Cabinet of Ministers can regulate all these things. And such regulatory bodies exist in many countries in order to restrict the monopoly of the Cabinet of Ministers and the possibility to abuse this monopoly situation. And the law on the Cabinet of Ministers should provide for such bodies being the state bodies with the special status, and they are to be formed with by the President with the participation of Verkhovna Rada. That would be the best option. But on the other hand, we see the problem of constitutional norms.
The third thing is that draft laws should restore the activity of state committees. They are today in the Cabinet of Ministers, but they are not mentioned in the law on the Cabinet of Ministers, so there's no guarantee that the new government would not like to cancel them as this happened before. So the law should clearly regulate the role of government committees and reinforce their role. One of the sources of inefficient and corruption impacts in the process of development of decisions of the Cabinet of Ministers is distance agreement, which happens in the dialogues between heads of departments, and the ministers can be absolutely removed from this process. So everything, as far as agreement is concerned, of different decisions should take place at state committees, at government committees, and the draft decisions should be published on the site of the Cabinet of Ministers, as this is done in the Parliament, so that every stakeholder, including Ukraine's citizens, can familiarize themselves with those solutions. So now I will talk about main changes being brought about by these draft laws. This is about the status of ministries. When we talk about the need to introduce reforms in Ukraine, we should first of all understand that reforms can be introduced only by ministers, and no one else, according to our constitution, has authority or opportunity to introduce reforms if this is not done by the ministers. And for them to have an opportunity to introduce reforms, you should reform the status and internal organization of the ministries. So the draft laws provide for making clearer and further delineate in the functions of ministries and other central bodies of power. We should understand that it is ministries that develop and form the state policy, and the rest of the bodies are just realizing their functions. They register something, they control something, and if they take part in working out the state policy, this should happen at the invitation of ministries, and as they say, in their free time. Second, deputies of the ministers should be appointed at the request of ministers, not at the request of the prime minister, which is being used for political quotas at the moment. And in this way, the ministers were deprived of expert support in their activity. The ministers should have also the positions of state secretaries, as in the cabinet of ministers, and state secretaries are top officials from among state service, and they should not be changed, replaced when the government is changed. Ministers and their deputies are replaced, but the state secretaries and the staff of the ministry should be stable. They should retain institutional memory and work in the interests of the country to realize the policy of the next government. The regulation should be reinforced about the duty of ministers to work on the basis of the analysis of the policy. The state policy should not be a fantasy of another minister. It should be a result of a policy in the sphere for which the ministry is responsible. It should be discussed with the public and should be enforced as a law. And because of this, there's a need to reform the structure of ministries. There should be another definition of department. A department in a ministry should be a big structural unit aimed at the fulfillment of the main functions of the ministry, not because of the number of staffers. They have up to 20 departments in different ministries now, which makes the analysis of the policy impossible. Also, those that are service in the ministry should be assembled in a secretariat, and secretariat should be one type, and this is in the coalition agreement signed at the parliament. If we understand that the ministries are engaged in working out and formation of the state policy, then evidently they don't need territorial bodies. Territorial bodies of ministries should be reorganized into other structures, partially local state administrations and partially central bodies of executive power. But in order to form the policy, we don't need territorial bodies. Today, this is the most acute problem for the Ministry of Interior and Ministry of Justice, where they have huge and numerous territorial bodies. And the last thing, collegiums, boards of the ministries. On the basis of our proposals, there should be a board in every ministry as a consultative and advisory body with which a minister should take advice. So no state officials should be there from this ministry, but apart from the ministries, there should be representatives of public organizations that are the recipients of this ministry. For instance, there should be a representative of the Council of Judges at the Ministry of Justice, of the bar, of human rights organizations, those with whom the minister should take advice as far as the policy of the ministry is concerned. So I think that these are key novels that pertain to the reinforcement and strengthening of the status of ministries as far as development and working out and the formation of the policy is concerned. It's very good that our draft laws, which we tabled almost 2 weeks ago, we sent them to major factions in the parliament and the administration and the secretariat of the cabinet of ministers. As far as the administration of president's reaction is concerned, Ivan Khilobok will tell us. The day before yesterday, we got an email from the Secretariat of the Cabinet of Ministers where they analyzed our draft laws, and there's a lot of constructive proposals, quite a number of debatable issues. We'll try to organize the discussion this week. We still don't know the reaction from MPs. We hope that at least several of them will take part in this briefing. Regrettably, just minutes before the briefing started, they called and said that they won't be here. We will be in contact with them, and we will try to organize the quickest tabling of these draft laws to the parliament, because ideally they should be approved together with the formation of the new cabinet of ministers. Evidently, this is not going to happen, but at least immediately after the formation of the government, they should be considered in the parliament. So now Viktor Tymoschuk, the co-author of these draft laws, we represent the Center for Political and Legal Reforms and the working groups on the administration reform in the RPR. And then Ivan Khilobok will speak.
Please be brief so that we have time left for questions and answers. I will just mention what Mr. Koliushko has not mentioned, but what I believe is important to mention to make Ukrainian system of administration more effective. There are several more innovations. One of them is to provide the right to the Cabinet of Ministers to delegate its powers to another executive authority, to do deconcentration of power. Now, at the Cabinet of Ministers, dozens of decisions are made. Many of them do not require the collegial consideration. Just the practice is such when the legislator doesn't know who to empower, then the responsibility is given to the Cabinet of Ministers. When it comes to the health protection issues, the whole Cabinet of Ministers is to be responsible for that. To avoid that, to make the responsibility individual, and also so that the government is not so overburdened, we suggest to go back to what we had in 2006, when the government had the right to delegate powers to the ministries and other executive bodies. This could be this refers to the regulations and some other issues. Another issue is the status of so-called other executive authorities, the agencies, the services, and inspections. And there are a few innovations here. The heads of these services, inspections, and agencies are to be clarified as the civil servants. They shouldn't be. It is important now that these people are appointed to these positions according to the legislation on civil service. They should be not political appointees, and such civil servants should be excluded from the political process. They shouldn't be drafting the legislation for themselves, like the tax service was drafting the legislation and regulatory acts for themselves. But actually, only the ministries are to draft the rules, and the leaders of such central authorities should not be campaigning for some initiatives in the parliament, so that they are not working on the draft laws. And also there should be a procedure of the acts of the president being approved by the ministers. The was the situation when the Cabinet of Ministers was performing the role of the control over the president. And now we want to make this procedure constructive so that the public policy is developed jointly by the president and the government, so that the public policy is not competing but the joint policy. Also, another proposal is to make more foreseeable the work of the government and less corrupt. It is to publish the regulations in advance, the draft regulations in advance. We understand that it will be difficult to perceive by the government because there is a desire to do it all immediately, and now they vote for dozens of decisions at the meetings of the government, and that is a negative practice because such decisions then are not well drafted. Now, as to positions of the state secretaries, we suggest to introduce the position of the secretary of the Cabinet of Ministers instead of the minister of the Cabinet of Ministers. This shouldn't be a political appointee, but a civil servant, senior civil servant, so that we ensure the institutional memory in the government, and that is related to the reform of state secretaries. And there are attempts to say that this reform is negative because people recollect the experience of 2000, 2001. In those days, that institution was introduced not correctly because that was the attempt of the president to control the government, and many mistakes were made because ministers did not have political deputies, but state secretaries were performing the role of the deputies, and the ministers could not function even in the issue of developing the policy. The idea of introducing the state secretaries in the ministries will be opposed because the ministers will have to sacrifice some of their powers. They have to refuse from appointing the heads of the departments in the ministry. Many things are to be transferred to the state secretaries in the ministries. The most difficult it will be with the human resources. Also, the patronage service should become a political cabinet where there would be no civil servants, because that leads to many abuse and violations. And that is it. Thank you. And now, Ivan.
First of all, I'd like to point out that the reform of the state administration is designated the first priority in President's Strategy 2020. So in the administration of the President, there's a full understanding that we should start from this. You should look at this reform comprehensively and see the entire system of administration as the structure and the stuff and the reforms that are being suggested. They have to do with the Cabinet of Ministers. And the ministries, we support most of the ideas. And the main idea of these draft laws, maybe there are some points that should be agreed, but first of all, we should delineate the responsibility of ministries between themselves and raise the responsibility of ministries and ministers for the introduction of this policy. It's also effective organizational structures should be installed in the ministries, and the procedures and processes of work should be changed. So these draft laws provide a framework for this, and it is very important. Mr. Koliushko mentioned that you should adopt, you should confirm this composition of the government together with the program of its activity. But we also think that every government should report on the results of their activity when they are going away, and it is very regrettable that this time the old government did not have the possibility to report to the parliament and the citizens about how they fulfilled the tasks that they put themselves several months ago. We think that the main function of the system of the state administration should be the system of setting aims and monitoring the achievement of these aims, both for the entire state apparatus and specific ministers and ministries. Of course, there should the Prime Minister and the government should be responsible for fulfilling those, and they should be a single team. Mr. Koliushko was very right in saying that there should not be a quota principle or a set of different ministers that do not work with each other, and they do not want to perform the duties that the state and the civil society expects from them. Any questions? I have several questions. First of all, you said that those draft laws are among the first priority, and they are the subject. They were the subjects of talks about the coalition agreement. But how the process that is taking place around the formation of the government agrees with the spirit and the letter of those draft laws that you are introducing today? Well, today the main attention of the leaders of political forces in our country is concentrated on looking for cadres and answering this tough issue. Well, this seems to be a different part of the job. However, we need both. I think that today we are losing as a country because during the previous time, or maybe even now, the Prime Minister and the President do not pay enough attention to the change of the rules that we are talking about. As I understand, they are today busy with looking for candidates and with talking about candidates, and this could be one of the problems. However, I do hope that they understand. Well, you know, they have put a lot of these proposals into the coalition agreement, so we hope that right after the formation of the government, these draft laws, maybe in a bit changed version, will be tabled before the parliament and will become the laws. I would like to emphasize just one thing. State secretaries were mentioned several times here. Someone may think that this is a sort of a aim for experts, but you know, the name of the position is secondary, but this is the tool of organization of the government in all the developed countries. This is a universal rule to have state secretaries. So, you know, I have mentioned the interview by the president of Estonia, who said that the success of Estonia is linked to the reform of ministries, because they have created the system of state secretaries. In half a year, they saw positive movements in many, many spheres, because this is a basis for reforms. I can add that the process is probably not going as ideally as they saw, as we should, but we should also think which ministries we want and what for. Why do we need industrial ministries like we have a coal industry ministry, but not the Ministry of Information Technologies? We should concentrate the state policy on some of the spheres, and like this, there are proposals that are being considered by the leaders of the state. But I'd like to emphasize that the responsibility for introduction of the state policy is with the Prime Minister, and maybe it is he who should choose the model and then be responsible for it. The model of his cabinet that he will lead and that will develop the country. During the briefings with Mr. Hanushak, Mr. Koliushko has more than once said about the process of decentralization, about the opportunities that we have. Is there a window of opportunity for the reform of the state service? How much time do we have to adopt this decision? How much time will the implementation take? As far as state service is concerned, we are within a very strict framework. If we do not adopt the law before the 1st of January, then the law adopted in 2012 may come into force. It is evident that we won't be able to adopt a new version in a it is unreal within 1 month, so the parliament will have to cancel the law of 2011, and the law should be adopted as soon as possible, because lots of things that we are talking about are impossible without the new law on state service. I think that the version is very, very adequate to be tabled before the parliament very soon, and within 2 months we think it is realistic to expect its adoption, and of course for the implementation we will need from 6 to 12 months, because there is a lot of new institutions and new serious rules like competition selection for all the positions, but the sooner we take the decision, the better the results. Will it be adopted as a package?
I believe that would be the best option if these drafts are considered in parallel and are considered as primary in December. Then that would have the best effect on the situation. Do these draft laws explain the system of communication between the ministries and the executive authorities, the issue of electronic documentation and increasing cooperation and interaction in electronic format, because now a lot of depends on how quickly someone will physically bring some documents or reports. Now the law on the Cabinet of Ministers and the law on the central authorities do not really regulate the technology of document circulation. And we don't see any possibility now to try in one step to resolve all the problems. The issue of introducing electronic documentation is very important, but that does not require any radical legislative solution. This could be done under the effective legislation today, and for that some technical issues are to be resolved. What should be the software, how these things are to be introduced into the regulations on the Cabinet of Ministers, on the regulations for different subdivisions of the Cabinet of Ministers, and at this level the electronic documentation is to be introduced. All these drafts, they give more responsibility and more opportunities, possibilities, more powers to the ministers. Every minister will be able to organize all the processes in his or her ministry, because now in the presidential administration we are introducing this electronic document circulation. People already are receiving the documents in electronic format, but every minister if understand that this will make his work more efficient, we'll be introducing it. Thank you for attention. I hope that very quickly we will all together get at the round table here and we'll discuss how this will be implemented. Thank you. Thank you.